unless you're going to talk or you have a question. I'll try to keep an eye on the chat on the side, so you can also post a question there. And what we're going to do today is we're going to talk about Title VII and what is gender according to the law, kind of the framework. I want to talk about the general legal framework that we're operating it here in Washington State and Seattle with, and then bring in a discussion of the readings. Okay, so like I said, if you have questions along the way, you can go ahead and unmute at any point and just say, hey, I have a question, or you can type it in the chat and I can get to it. We'll also have time for discussion partway through the class. I'm not sure if we're going to go the full time. We'll see. We'll see how it goes, but we definitely have a number of things to discuss. So hopefully everybody's warm and safe, and we're recording it for those who can't join. Also, you can see I'm at home. Of course, the rest of the world, for the most part, went on today, but school's canceled for my young ones. So they have lots of cabin fever, and my usual office is being remodeled due to flood and other things. So we may be interrupted. We'll see, but hopefully not. Okay, so let's go ahead and get started with the PowerPoint. Let's see here. Share. Okay. It's failed to start. Hold on a second. I will then do desktop 2. And swap display. So can someone help me out and tell me, are you seeing my slide or my notes page? Is anybody there?
No, we can't see it.
Okay. Thanks for letting me know. This shouldn't be this challenging. I've used this before, but let's see here. Okay. Let's see here. I love technical challenges. Well, how about this? I will just make this larger, and when I play it, I'll see if I can just play it on one screen. Okay, we're just going to do it not in full view, but I'm guessing you can see my slide now. Is that good? Hey, Jay, could you tell me, can you see my slide that says what is gender?
Yes.
Okay, excellent. So we're in business. Okay, so let's go ahead and get started. So we're going to start talking about the legal framework and Title VII and what are considered unlawful employment practices. Now, we're going to focus on employment law to get started, and really that is going to be the main focus of the cases we're going to cover in this class. Not all, but a lot, because of the fact that the issue of gender and sex comes up so often in the employment context, and that's where the majority of the law is. So if we were to look at Title VII of the 1964 Civil Rights Act, it talks about unlawful employment practices for an employer, so they can't fail or refuse to hire or discharge any individual, and as it says, or otherwise discriminate with respect to, and see it says his, compensation, terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin. And they also can't limit, segregate, or classify employees or applicants for employment in any way which would deprive or tend to deprive them of employment opportunities or otherwise adversely affect their employment status. Now, there's a number of parts of this that we're going to talk about and how this breaks down into actual legal claims. And some of the language, including the adverse impact, is a really important part of Title VII. Okay, so there's two types of Title VII claims that you'll typically see. The first is disparate treatment. And so that is where an employer's rules or decisions, or an institution's, if you think about like a school, but here for an employer, they treat an employee less favorably than others because of a protected status. So again, race, sex, religion, or national origin. And disparate treatment claims require discriminatory intent, and that can really be difficult to prove. We're going to talk about that more in the quarter as we go along, because someone, you know, it's hard to find that smoking gun that where someone says, oh, I just don't want to have any women, or you know, in Washington State, let's say, you know, for them to actually explicitly state that discrimination is their intent. Now, the other type of claim is disparate impact, and that requires a plaintiff to show that something that's facially neutral, so a facially neutral job requirement or policy disproportionately affects one sex and is not related to job performance. And in this instance, there is no discriminatory intent required. But then there's a lot of proof that's required, and typically in the form of statistical analysis. Okay, so those are the two types of claims that we see. So if we're going to look at, okay, how would you prove this? So if there's a disparate treatment case or a claim that an individual wanted to bring, they'd have to bring what's called a prima facie case. And so that's the moving party, which is the plaintiff, would have to bring that. And the prima facie case is, we'll get into the details of that, but basically they have to show that there was some type of adverse action, okay? And then the employer, so the defendant, can come back and say, well, there's a bona fide occupational qualification. And we saw that in last week's case, right? So is it a BFOQ? So that means is there a legitimate and non-discriminatory reason why they have this requirement? And then what can happen is the plaintiff can come back, so the employee can come back and say, well, this is pretext. So let me talk you through these a little bit. And I'll also briefly show you the disparate impact test as well. So we just talked about disparate treatment. So we're going to disparate impact, where it's also a prima facie case. The defendant can come back and say, well, this is a business necessity. And then the plaintiff has a chance to rebut with trying to show that it's pretext. So let me get into the weeds with this. So if we think about a prima facie case for a plaintiff, you have to show that you're a member of a protected class. Now, in this class, we're talking about gender and law as the title of the class. Under Title VII, they say sex. And so we're going to talk about and how the law conflates sex and gender. So in this case, you'd have to show that you're a member of a protected class. And so this is for federal law. So again, remember, we're talking right now about federal law. And then the next part of the prima facie case is they have to show that they suffered an adverse employment action. So that could be all kinds of things. It could be, we typically think of somebody being terminated, right? But that could be that you were maybe demoted, that you were transferred to a different position. Maybe they even took away job responsibilities that you really liked, that basically impacted you in an adverse way. Or, you know, they could move your office, say from a nice office with windows to like some cubicle, say for example, right in the middle of the entire office. So things like that, okay? And you have to show that people who weren't members of the protected class were treated more favorably. So like in our case last week, right? So showing that men with preschool age children were hired, but they didn't want to hire women with preschool age children, okay? So that's the prima facie case. And when you're talking about showing in the prima facie case in the context of what we're learning in this class because of sex, there's a lot of different ways that you can show that, but it's can be really challenging as well. So there's things that are descriptive stereotypes that we typically think of. So like saying very sexist comments. You can think of some workplaces, for example, that have, and we're not getting into hostile work environment claims right now, but have, say, posters of, you know, scantily clad individuals that can make it very comfortable for people. So, you know, those type of descriptive stereotypes. And then we think of prescriptive stereotypes, so expectations on conforming. So if we think about performance and expectations and conforming with perceived norms of gender performance. And so when we get into, for example, Price Waterhouse for today, right, we're going to talk a little bit about that. So what is it? And so you can show that as well. And then there's also, Yoshino talked about a concept of covering. Some of you may be familiar with it. There's people have written about it in different contexts, but really thinking about also, does the environment require somebody to act in a specific way to be successful, right? So if we're, again, that's like the prescriptive stereotype that you have to kind of cover so that you're acting one way in your work environment so that you can succeed there. And that's what the expectation is. And it's because of sex, okay? So if we're going to get to, kind of this whole thing of, we think of, I have this kind of bullseye thing, but racial animus or gender, sex animus, whatever the animus is the center of it. And then as you go out and we think about, I put rational discrimination because here we're going to talk about BFOQs and what are these bona fide occupational qualifications. And I really want to say up front that there are and I mean, I know you know this, but there's so many things that are just, we could say, many would argue morally wrong. Some might not see it as morally wrong, but others might say it's just unfair treatment, but it's not illegal, okay? And so we'll be talking about those discrepancies too. So anyway, what is rational discrimination? Not according to me, according to the courts. And then we think about how discrimination, so we think of things like, semi-conscious or unconscious bias, right? So I can hear somebody typing away, so if you could mute, that'd be great. And then we think about workplace structures as well. So what are the policies in the workplace? What's the management structure? Things like that. And then what is the culture of the workplace? And a lot has been coming out about workplace culture as well, particularly more recently. So how does this fit together? So if we're thinking about a bona fide occupational qualification, this defense allows for employment decisions to be made on the basis of protected status. And it's an exception to Title VII and it is a complete defense. So if a defendant shows it and it's held up, there's not showing a pretext, then the case is dismissed. Okay, so they have to show that the requirement is necessary to the success of the business and that a definable group or class of employees would be unable to perform the job safely and efficiently. Okay, and here motive doesn't matter, or at least it matters, but it's not significant. So we think about, for example, like models and actors, if they were talking about for purposes of authenticity. We'll be looking at some other cases in which this has been debated. I think in the case of sex and gender, companies have been moving more and more away from this, but a lot of the early cases are really talking about this in the context of even things like when we think about, when we're on the airlines, right, and a steward or a host, for a period of time, there was quite a debate as to whether or not they had to be, the gender identity needed to be female and present as cisgendered women. Okay. So let's talk about pretext, and then we're going to get into our case and we'll have a discussion in a little bit. So pretext. So after the employer has shown that this is a bona fide occupational qualification, or at least attempts to, the employee, so the plaintiff, can come back and try to say, hey, this isn't credible. So either it's factually incorrect, or if it's factually correct, it's not the real reason. So it's essentially a lie, okay, or a cover-up. Last week we looked at the Phillips, right, versus Martin Marietta Corporation. I'll have to fix this. I changed this from a PDF to this, and some strange translations came with the fonts to numbers. But the Phillips versus Martin Marietta Corp that we talked about last week, right, talked about sex plus having preschool age children. And so you need to have a comparator among those who are of the opposite sex or opposite gender, if we're looking the way the courts do in a binary way. And then we're going to get into intersectionality next week, because sex plus honestly is quite complicated with intersectionality, and so we'll talk about that when we're thinking about multiple axes of oppression intersecting and how that impacts cases. Okay. Okay, so then we have also mixed motive cases. So in real life, we know things aren't just usually typically neat and simple, right? So for example, we'll get into the Price Waterhouse case by Ann Hopkins, and they said that there were some because of sex factors that contributed to her not making partner. And so if there's a combination of things that are because of a protected class and not, the question there was really, can then you still have a case, right? And so, the court gets to weigh this. And so this was what they call the mixed motive. Okay. So if there is discriminatory reason, and that was what they call a motivating factor, which that's a whole huge area of interpretation as well, is what is a motivating factor, then you can have potentially a case. So let's talk about Price Waterhouse versus Hopkins. So can someone, or would somebody volunteer? There you go. See my lovely desktop. Would somebody be willing to share their case brief with us? And hold on, let me stop the share for a second. Okay, so you're there. So what were the facts of this case? Can someone just start with that? And you can go ahead and unmute. Anybody? There's all these people here. Let's see. I'll give you a minute. So what were the facts in Price Waterhouse? Thank you. Mackenzie? Or no, who? Is somebody trying to talk? Let's see. Okay, I can't hear you, but you're unmuted, Mackenzie. let's see. How about, who wants to go?
I can go.
Thank you, Emily.
Yeah, so sorry, I need to pull up my Google Doc. So I said that for the facts of the case that Ann Hopkins, she was member of Price Waterhouse Corporation, and she was trying to get promoted to a partner,
Mm-hmm.
and she's claiming that her former employer failed to promote her because of gender discrimination. And the facts say that Hopkins' application was the only female nominee out of 88 others. And they also provided some background information saying that Hopkins was really good at her job and she secured a really good deal, giving the company millions in profits. But
Yeah.
even though she didn't receive the partner promotion,
Mm-hmm.
and the way that the company uh, decides whether or not someone is promoted to a partner is through like the reliance of comments and recommendations of other members. And in the case, it seems like a lot of the facts about, or not the facts, but the opinions of Hopkins were, some were like gender based and some were not. Um, some said that she was aggressive and others openly couldn't fill the position. So there were like a kind of a spectrum of things happening. And the court, uh, yeah, and that's basically the facts of the case that I have.
Yeah. So great. That's really, so there's these performative aspects, right, to why Ann Hopkins didn't make partner. Um, and, so, I mean, Emily or someone else can respond. It doesn't have to be Emily. But so, part of her argument, right, was that if she was a man, this wouldn't have been the same type of issue. So let me just briefly go over procedural history, and then we'll get right into the IRAC for the case. Right, so she sued in federal district court, and they found that they found that her employer had unlawfully discriminated against her on the basis of sex. Um, and so then the Court of Appeals affirmed that. So basically, they disagreed, though, about the level of proof needed to establish that sexual discrimination occurred. So here we're talking about that mixed motive piece, right? So can someone share what their issue was for this case? I see you trying to talk, but we can't hear you. I don't know what's going on. Um,
I
someone,
can,
okay, who's here?
Sophia, hi. So the issue I have was the Court of Appeals correct in placing the standard of proof at clear and convincing evidence for the employer's Price Waterhouse to prove that they would have made the same decision to place Hopkins' partnership candidacy on hold without discrimination?
Great, thanks, Sophia. And so, Sophia, what is the usual standard of proof in a civil case?
It's a preponderance of the evidence.
Right, so typically it's preponderance, which is like just a little bit more than 50%. But clear and convincing, and then we have beyond a reasonable doubt, which is the highest standard of proof, right, that we use for criminal cases. So if we have this preponderance and and beyond a reasonable doubt, then somewhere in the middle, they don't quite quantify it, but it's clear and convincing. So it's a higher standard of proof that they were using. So then for the case, we know that the rule was looking at Title VII, right, of the Civil Rights Act. And we're going to jump to the conclusion, what the court held or what they did, and then we're going to go back to the analysis. So could somebody go ahead and share with us what the court decided in Price Waterhouse?
Oh, I can go.
Thank you, Jay.
Okay. So they remanded the case so that a determination could be made about they had to like see, so because it was evident that gender played a part in the employment decision, and Pricewaterhouse wasn't able to convince the judges that concern for Hopkins' interpersonal issues were legitimate and that they would have resulted in the same decision for that behavior alone, and like they weren't able to prove that concern is legitimate. They weren't able to determine if that evidence was strong enough to hold that they would have done the same thing without the discrimination. So then they remanded it.
Right, and so, and they gave the lower court a lot of guidance in the analysis, right, in what the kind of the standard that they wanted them to use. So what they were talking about is interpretation of because of sex. So great job, Jay. So what was the court talking about here when they were, trying to parse out this, what it meant because of sex discrimination in the context of Ann Hopkins? Who is our volunteer? I know it's always a little weird online. So I can call. Are you still, can we hear you now? Is it working? No,
Maybe
we
you
still
should type
can't.
your answer.
Yeah, you could type your answer in the chat. We can all see the chat. No, it's not working. Or, I'm not sure. I'm sorry, but Mackenzie, can you hear me? Is that up? You can hear me? You could type your message in the chat. Can you click on that or type what you're thinking? And while she's doing that, can we get someone else who would be willing? I can call on people, but I'd rather you volunteer.
I can go again, but is it okay if you repeat the question?
Yeah, well, I actually want to get somebody. I appreciate you offering to go get Emily, but I want to get get other people to volunteer. So it's, what is the analysis? So what did the court, like, what was their analysis? Why did they decide the way they did?
I can go.
Oh, thank you. Thanks, Natalie.
Okay. I have no idea if this is right. Well, I'm like pulling up my
That's why it's class.
But I said they were struggling with whether the words because of meant solely because of sex. So like meaning that multiple factors resulted in Hopkins not receiving partner, one of which could have been sex discrimination.
Right. And that's where this mixed motive comes in, right? And so what were these multiple factors that they're talking about?
Well, like they talked about that she was like the language that they used in that they saw in like the forms could be interpreted as inherently or as sexist comments, like what, like the comments about how she dressed or about how was she aggressive or not, but then the aggressive part could also be like a legitimate concern as an employer for an employee about how they behave with other employees.
And this, right, the decision for partnership was made by a vote of partners, right? And so they have these evaluations of her and then other things. So so it was that, right? There was some, it seemed like, discussion Just her general presentation wasn't quite feminine as enough. And one of the things we're talking about is this difference between what's called but-for causation or direct causal connection, right? What you're talking about, or what, like how closely tied does it need to be? And so when we think of a lot of cases, particularly, talking about civil cases here, typically you show for liability that but for a certain action, right, there wouldn't be liability. But if you have multiple intervening causes, right, then it can be really difficult to show what was, like, is there one cause or multiple causes? And then if there were multiple causes, like you said, does it have to be just because of sex, or could there be other things? Now, I mean, most of us know, I can think like when I was at a law firm and other places, and it still goes, there's kind of that saying, if you're aggressive and act like that as a woman, they're going to call you what? But if you're a guy, they might call you some other things, but it's not quite as derogatory, right, as some of the pejorative terms used for women. So, here, right, that's part of what she's talking about. So let's talk about the concurring, Justice White and Justice O'Connor's concurring opinions, and then talk about the context of our readings. So what did Justice White have to say in the concurrence?
I can take that.
Thank you, Emma. Yeah.
So basically he agrees that there are both legitimate and illegitimate factors going on here, but he thinks that, or he disagrees because he doesn't think that Hopkins has the major responsibility in proving that the illegitimate factor or her gender was the sole or only reason that she was not chosen to be partner. I think that's kind of the gist.
Yeah, that's great. And then also he talks about the standard of proof, right? So he also thought that it should be preponderance and not a clear and convincing. So it shouldn't be such a high standard of proof. So great. And then what was Justice O'Connor saying in her concurrence?
Hers was a little bit more complicated for me to understand.
Yeah.
But basically she focused a lot on the difference of because of, and how the plurality said that did not mean but for, and she said that they're the same thing. And she I felt like she put some added emphasis on the discrimination that Hopkins felt in the workplace. But she also still said that that's not necessarily proof that gender discrimination was the reason that she was held instead of becoming partner. And so she, the standard of proof that she prefers was slightly different. I think she also wanted preponderance.
Yes. Yes, she did. You're correct. Yeah, great. And does anybody want to add some to what Emma was saying? So she took on two of them. So thank you, Emma. Anything else?
O'Connor made a note about stray remarks in terms of what the plaintiff can use in proving employment or discrimination in employment decisions. So O'Connor argued that stray remarks, like the comments on Hopkins' makeup, which are statements that were made by people who weren't making the employment decision, but also statements that decision makers made outside of that context of making the decision are not enough to count as direct evidence. So a lot of the comments that were made about her appearance and how what her makeup looked like, her hair looked like, they're not enough to prove gender discrimination for O'Connor.
Yes, not enough, exactly. So I'm glad you brought that up. Yeah, and she was talking about how the words because of don't necessarily mean but for causation. And then when you think of stray remarks, I mean, I think, this case is one of the landmark cases in employment discrimination. We're going to look at much more recent cases. Because if you're thinking about hostile work environment, even today, like they still use the stray remarks doctrine, which is challenging, not only because of sex or sex cases, and again, please note sex and gender cases, but also race. So somebody could say something, like the C word, and most of us would be like, that's clear that they have like some problem with women, right? And some judges would consider that enough evidence and others not to be part of whether or not they're going to decide if it was just a stray remark or if it actually is more proof of discrimination. Let's see here. Now, how about Justice Kennedy's dissent? What does Justice Kennedy have to say? Anybody? Someone's building up their nerve. What's kind of interesting is we look at the current court, and both O'Connor and Kennedy were Republican appointees and considered more conservative, or expected to be more conservative, but compared to the current court, they would be considered much more moderate in their decisions. So, even by today's standard, for example, Justice O'Connor voted, as well as Kennedy, in many discrimination cases for, you think about like college admissions and other things, for allowing cases to move forward and for showings of gender discrimination, but still was very limited in what they would agree to. So they've always kind of been on the margins. I think compared to social science, it'd be considered still very conservative. But legally, if we're going to just look at where the court is, right, they actually are interesting justices to look at. So who'd like to talk about Justice Kennedy's dissent? Do I have a volunteer?
Someone typed something.
Oh, yay. Thank you, Mackenzie. Okay. I'll unmute you since we can't mute you, but can everyone see it? So O'Connor thinks that it doesn't make sense that the defense should have to use direct evidence to prove a legitimate reason. Oh, you were talking about O'Connor. Mackenzie, were you also trying to talk about, dissent, too specific of a case to create a new evidentiary framework. Believes the burden of proof should always be with the plaintiff. In this case, the plaintiff should have to prove that discrimination was a substantial cause, right, affirmatively. So basically, right, he thinks that they should remand the case for entry of judgment in favor of the employer, right, in favor of Price Waterhouse. Right, the district court found that the comments did not prove intentional discrimination. So like Tara was talking about earlier, the stray remarks doctrine. And since Hopkins allegedly did have problems dealing with staff and peers, they can't say that she would have necessarily been elected to partnership. And so according to Kennedy, Hopkins didn't meet the standard of proof, and so should have been for Price Waterhouse. Right, and then talking about how the burden of proof, like Mackenzie, it should always be with the plaintiff, right? So great. Any questions or comments on Price Waterhouse at this point? We're going to be jumping in back into the discussion. Hello? Okay, hold on, let me get desktop one. Okay, so let's go to the Title VII of the Civil Rights Act, excuse me, of 1991. Okay. So, and I'll be posting all of these slides, but okay, so we're going to bring these together, but let's talk about the Civil Rights Act of 1991. We're going to talk now about the state, Washington State, and then Seattle, and then we're going to bring them together, okay, to unpack the readings. So in 1991, there was the Civil Rights Act that was passed, and it talked about on a claim in which an individual proves a violation and demonstrates that they would have taken the same action in the absence of the impermissible motivating factor, the court can grant relief. That's what it's talking about. So they can do injunctive relief, which is where they're telling the employer to do something, right? Or someone to actually do something like hire someone back, give them back their position. We typically think of it in the case of, say, if they were going to cut down or take down a historic monument, they can order them to stop. And then, let's see, it talks about then some of the language, shall not award damages or issue any order requiring any admission, reinstatement, hiring, promotion, or payment that is described. So let me get to the second part. So this is really the main part. So an unlawful employment practice is established when the complaining party demonstrates that race, color, religion, sex, or national origin was a motivating factor for any employment practice, even though other factors also motivated the practice. So this came really, in the wake of, with the amendments to Price Waterhouse, because this whole question is to, and the courts still weren't quite clear about this motivating factor and mixed methods. So even if there were, right, after this, the legislature said if it was a motivating factor. And like I talked about, there's a whole body of case law regarding what is a motivating factor, okay? And how much, like, that needs to be, and what level of proof of evidence needs to be given to be a motivating factor. So we've been talking about Title VII, which is federal and is the floor, right? So under the Constitution, we know that, federal law is the supreme law of the land. It is, you can't take away anything that the Constitution grants. But you can, and states can give additional rights as well as local governments. So they can take away, but they can add on. So if we look just where we're situated in Washington State, we have the Washington Law Against Discrimination, which is under the Revised Code of Washington, so our state statute, and that's more protective than Title VII. And this, under state statute, and I'm sure many of you are aware, but it includes sexual orientation and gender identity. It includes things like veteran status. They have the phrase creed, so your belief system. So there's a number of things that are in addition to the protected categories under federal law. So I give you a link here so you can look at it more closely. So we have more protection in Washington State. And then if we think about Seattle, and I was telling you last class how, the city of Seattle, similar to San Francisco, has really been on the cutting edge with a lot of things in the employment context, much more progressive than most municipalities. And so, we think about, right, we have state law and then we have municipal ordinances. And so Seattle has its own fair employment practice ordinance. And so it talks about discrimination and harassment, and I just provided one section for the municipal code and a link to the entire thing, but it says you can't discriminate by reason of race, color, age, sex, marital status, sexual orientation, gender identity. It includes genetic information, political ideology, right? So there's a lot of things that are protected in the city of Seattle. Okay. And also, just to kind of talk to you about the administrative counterparts, if we're thinking at the federal level for Title VII, where the administrative agencies that are helping to enforce these laws, I'm sure you're familiar with the EEOC, or the Equal Opportunity Commission. And then we also have at the state level the Washington State Human Rights Commission, which enforces the Washington law against discrimination. And then at our municipal level in Seattle, we have the Seattle Office of Civil Rights. And so if somebody has a claim, and we'll get into this more when we specifically talk about employment law, they have the option to go to one of these agencies, and the agency may decide to take their case and then advocate on their behalf. Okay, so we have the Seattle Fair Employment Ordinance. So I want to show this to you, and this will be included with the link. But if we just look at the United States and the different states and what they cover for whether or not they have state law that explicitly prohibits discrimination based on sexual orientation and gender identity, is either the olive green slides. Is everybody seeing that, or did I not? I thought I was doing screen share. Am I still doing screen share? Looks like it. Maybe. Let's see. No, I am. Okay, great. So you can see the olive green, right? So Washington, Oregon, definitely West Coast, Colorado, New Mexico, right, and the Northeast. And then we have the ones with the stripes, right? State explicitly interprets existing prohibition on sex discrimination to include sexual orientation and or gender identity, okay? And then we have the light green, which is sexual orientation only. And then the rest, right, the beige color is no prohibitions at all. And so this is really important, and we're going to also talk about marriage later. So, but we think about this really uneven landscape, right? And so I have a few questions for us to discuss, and then we have a few hypotheticals we're going to do to discuss as a class. So the first thing is based on the course readings. So you read both Curra and Greenberg's pieces. What would they argue is problematic, or what's the limitations with Title VII and its language and scope? So let's just start with Curra's piece. So he's talking about they're talking about the transgender umbrella in that chapter that we read. So what are some of the challenges? Let me even back up. What is this transgender umbrella that Curra is discussing? I see Mackenzie just posted. The whole point of the gender rights movement is to expand our understanding of gender and undermine the boundaries. But with the law, we need more specificity. Yes. So law, again, likes to put things in specific boxes and boundaries. And oh, I mean, part of the language, right, we know with problem with Title VII is that it conflates sex and gender. I mean, that's just it, the bottom baseline because of sex. And then Kara talks about some of the cases, right? So there's the Doe case. There are the two cases that we're looking at. Let me see, pull up the individuals in school, right? The high school photo case, that was Youngstown or Young's Blood. I'm trying to remember the last. And then the other one, Doe, who was, they were gender nonconforming, right? And the principal was actually, can you think how horrific that is, doing a clothing check every day and sending them home regularly. And so Kara's talking about it, and particularly in the context of public schools, because that's really a clear interaction of the state with individuals. And so it's a clear, what we call state action. And so it's a great test case or type of case to write about. And so, you know, I was talking about this umbrella that really doesn't show the complexities of issues. And the reason I had you read Greenberg's piece as well, talking about intersex, is, right, there's this whole continuum that we know of gender, but then also when we think about and gender socially constructed, right, performance of gender, what that means, how people choose to express themselves. But then when we also think about sex, people often try to, you know, think of it in binary ways, but it's not necessarily, and it is not just binary categories. And so we'll talk some more later too, but right, the intersex video, you know, Greenberg's piece was talking about these cases in which, because of society's expectations and norms surrounding gender performance, and some parents' desire to want to be able to ascribe, you know, clearly they want to have a clearly presenting cisgender child, they're assigning and making decisions for children as infants, right, if they are born in some way intersex. And so there's a lot of medical issues. And so we're talking about the employment context, but there's a lot of cases also surrounding informed consent and medical malpractice, and then also just rights of minors as well, right? And so there's this whole, you know, movement, I would argue rightfully so, for young people to be able to make their own decisions and not have it decided for them once they're old enough. But these are ways in which, right, law and gender and sex are coming together. And so the whole point of these readings was really to show you, and I'm sure you're aware, you're going to school at Seattle University, it's 2020 now, but these issues are far more complex than the court, most courts recognize or seem to be able to grapple with, right? And so in both Kara and Greenberg's piece, they also talked about the limitations of the court, right? Well, really depended on the judge, and you know, how the judge looked at the issue, interpreted the issues, right? And they talked also about this whole issue as to whether or not, I think both politically and legally, this issue as to whether or not it was an immutable characteristic, right? Gender identity. And that's one of the things where, you know, discrimination law has very much focused on things that are considered immutable characteristics. And so there's been a conservative movement to say, and so it's talking about the tension too, if, you know, this whole debate, you know, science is pretty clear, it's not a choice, but a lot of conservatives are still talking that way. And that still influences the courts. So any questions at this point? I see, not yet. Right, and I saw some of you talked about the current case that's pending before the Supreme Court, right? The Bostock versus Clayton County case. So we'll see if they're going to expand sex to sexual orientation in the workplace. That would be huge. But with the current court, we'll see. So anybody who did articles, let's see, in relation to that? Would somebody, we're going to talk a little bit about our blog posts now and how they relate to the readings. So would somebody be willing to share? I saw a few people had posted articles in relation to the pending case. Let's see, I can pull it up. Anybody? Pull it up now. Let's see. So this is our opportunity, and this is where we're going to start each week in having everyone discuss their article and how it relates to class. So I could get started calling on people, or you can go ahead and volunteer. It's up to you. I'll give you a moment. So this is a chance for you to tell us about the outside source that you picked and how it relates to the course readings. All right, well, Hamza, you're lucky since your name is first in the list. Your last name. Can you go ahead and share your article with class?
Oh, yeah, sure, I can do that. Can you hear me well?
Yep, we can. Thank you.
All right. So my article was called Supreme Court Considers Whether Civil Rights Act Protects LGBT Workers. So basically centered around the Supreme Court struggle to decide whether the Civil Rights Act of 1964 prohibits job discrimination based on sexual orientation and transgender status. So there's a lot of information that was inside of that article, but just to get the gist of it, as of now, job discrimination based on sexual orientation and transgender status is illegal in several states across the U.S. But so right now, the court, employees of the LGBT community who would like to gain basic protections that other groups have, should the court decide that Title VII of the Civil Rights Act applies to them as well. So basically, like we read inside of our readings, Title VII of the Civil Rights Act outlaws discrimination based on race, religion, natural origin, and sex. So when trying to find an answer on how broadly to interpret sex, the justices look at two arguments, one of which dealt with a pair of lawsuits from gay men who said that they were fired due to their sexual orientation. So in this argument, one of the Supreme Court justices by the name of Justice Alito said that it would be absurd to conclude that Congress intended back in the day to protect gay people when it passed Title VII, arguing that to do so would be to try to change what Congress and the people of that time understood by it. So in response to that, a lawyer by the name of Pamela S. Carlin, who is the lawyer of those men, gave an analogy by saying that when an employer fires a man for dating men, but not for firing a woman for dating men, then that act in and of itself violates Title VII because you're giving one standard for women that you're not giving to men, which in this case would be dating men. So other topics that were inside that article were things such as transgender athletes, bathrooms, and things like that. And towards the end, Justice Sotomayor basically urged the court to act to protect historically favored groups towards the end of the arguments. So I relayed the information in this article to the case brief on Price Waterhouse, sorry,
Mm-hmm.
versus Hopkins, as well as the reading by Paisley Kura. So Title VII came up quite frequently in Price Waterhouse versus Hopkins, and it was kind of centered around that, specifically when it referred to the decision made by the courts that an employer had not violated Title VII if it could prove by clear and convincing proof that it would have made the same decision in the absence of such discrimination. And when discussing transgenderism, one of the topics that Kura touched on was the topic of transgender rights as civil rights, as well as the overall difficulties that transgender people have faced having the rights recognized in school, the workforce, etc.
Okay.
And yeah,
Great.
kind of literally just like read word for word what I wrote.
Yeah, great.
Yeah.
Great. My puppy's for Dash. Say hi. Say hi. That's the one that wants to come to class. So his name's Dash.
Oh.
Thank you, Hamza. That was really great. So did anybody else post about this case? So we'll do the related articles. Let's see here. I saw a few. Go. Let's see here. Well, then we'll go ahead and I'll just start going through who's here. So, Jay, could you go and share your article?
Yeah.
And thanks, you know,
Let me get it. Mine was, can someone be fired for being gay? And it's from September 23rd, 2019. So I guess like around October, like the beginning of October of last year, the Supreme Court was scheduled to consider whether or not Title VII would guarantee protection for gay and transgender people against workplace discrimination. And so it mentions like some landmark cases in favor of gay rights. I didn't like list them, but it listed like one that was like protecting lesbians, and there were just like two other that I don't know off the top of my head. And since the Civil Rights Act doesn't explicitly identify, I guess like it doesn't include explicitly like transgender people because it's working in the binary. People who are transgender or non-binary or intersex people are, I guess, like left out of definitions of gender, or like it hasn't actually been established through procedural history yet. And then in the other like later half of the article, it also starts talking about whether or not a person's sexual orientation should count as a sex-based classification. And the lawyers who do argue that say it's because it can't be defined without reference to someone's sex, which is similar to what the person before me was talking about, how discrimination like based on someone's sexual orientation has to do with sex, like someone's, I guess, like biological sex or gender. And so it mentions how currently in a lot of states, people are still legally allowed to fire employees for being gay, and that there are still not a lot of protections, even though the Obergefell versus Hodges case occurred, ruling in favor of gay marriage. And so even though like those things have happened, we still don't have, I guess, like definitions within like Title VII that are inclusive of like millions of people who either don't fall within the binary or their sexual orientation.
isn't like being recognized.
Right. No, that's great. And yeah, I mean, it really is this, just like we were talking about, the legal definition. And so we'll see what the court's going to do. We're going to cover the Burgeville case later this quarter and read the decision. Part of what you're getting at with that case, Jay, is the grounds on which it was decided, because it was decided as a due process fundamental right to marriage case, not as under the Equal Protection Clause, in looking specifically at the issue of sex and gender. So great, thank you very much. Let's see, Sophia Annis, could you go and share your article with us?
Sure. So my article was titled "Transgender Boy Sues New York State Over Sex on Birth Certificate," and it's from the New York Times. So in Albany, New York, a transgender boy in the case goes by the initials MHW, filed a lawsuit in federal court arguing that transgender minors should be allowed to correct their New York State birth certificate. And they claim that it's a discriminatory policy forcing them to rely on their birth certificate that inaccurately portrays his identity. And an interesting point to notice is that in New York City, individuals, transgender minors, are allowed to correct their birth certificates, just not in the state overall. So the boy is 14 years old, and he now lives in Houston, Texas, and already began hormone replacement therapy in September and October, legally changed his name in a Texas court. And his passport and social security card lists him as a male. And so I related this lawsuit to the article, Paisley Kerr's article, that talked about the two cases, Doe and Youngblood, that had to do with high school age students and stuff along the lines with gender identity. And so I thought that Doe's case, since it dealt with a transgender minor, and it was successful, could potentially be something for precedent for the MHW's case, even though the Doe's case was about clothing, and this is about birth certificates. It still could potentially be used. The main point that was successful in Doe's case was something I don't think could be valid today, was discrimination based on disability, because that's just not realistic. So the point they could possibly use was the right to freedom of expression, because you're not able to, I'm not sure exactly how this play out, but not able to express the right sex on their birth certificate. And another point that I thought might help the case win is just more in analyzing it, is that the gender identity and gender expression of MHW follows the binary, which was the same in Doe's case, but not the same in Youngblood, which wasn't successful. So I just thought that was a factor that might contribute to that.
Great points. Dean Spain, who's faculty at the law school, they've written quite a bit about state documentation and what we call documentary proof, right, or evidence that we need, from birth certificates to ID, like you're talking about, passports, et cetera, and how the state, through those forms of documentation, regulates and controls, people's, not necessarily expression, but the ability, well, it is expression, legally, to reflect how they self-identify. And one of the major legal issues that has come up that manifests itself outside of this is that often people are subject to violence based on their gender performance if they're at times if their identity has like documentation, say showing it like at a a store or a police stop or something like that, doesn't comport with their expression. And so this is a huge issue. Dean Spade and many have worked on it quite a bit, and I really thought you did a great discussion there. And you're right, as far as the discussion they had in Doe regarding the disability piece, right? And then the other avenue of free expression, so under the First Amendment. And so, yeah, the disability wouldn't work the same today, but there's still a lot of people who believe that, unfortunately, right? And so there are certain treatments that people are still making minors be subject to. So thank you very much, Sophia. So Sophia Firely, can you please? Thank you.
So my article is from the Seattle Times, and it just talks about a law that was actually, since writing this, they decided to reject this. But the California legislature was talking about banning intersex surgeries, and I just thought it kind of called back to the Greenberg article in the sense that like there's this whole section that talks at the very end about like all of the different factors you have to weigh, just like the impacts of the surgeries on the child, and then also the idea of consent of the child, and then kind of like parental autonomy, etc. So all the ban would do was ban surgeries deemed unnecessary by the Medical Board of California until children were 6, just kind of to give parents time to like learn more about their child being intersex and like try to decide how they want to parent that rather than making a decision right off the bat. And so, yeah.
Yeah. Okay. And so, yes, it definitely relates to Greenberg's article. This is a really important legal issue. Actually, in reviewing the videos for today, since we're snowed in, I had my 10 and 6-year-old watch them too. So we had a good discussion. And it's interesting to see how kids respond as well. But just the whole idea that, right, such a permanent decision can be made at such a young age. Yeah, it's definitely, it's a human rights issue that people are really talking about. So thank you. Let's see, just going down the alphabet. So Emma, can you share yours?
Yeah, so I found a case that I thought mirrored Price Waterhouse v. Hopkins pretty well. So there's this woman, Carrie Campbell, who's suing her San Francisco-based law firm, Chadburn Park, because she brought up that she didn't think that her payment was comparable to her male colleagues, and then she was notified that she would be terminated by the end of the year. So she said that she was like among the top earners at her law firm and had over 20 years of experience behind her, but she was still in the bottom 1/3 of compensation in terms of all the partners. And she saw that this was like a trend across all the women in the office and the women partners. And so like in filing this suit, she kind of revealed the way that the partners chose, or like kind of decided how the payment was, and they were like given points and didn't really give a lot of information on how you got points, but it was clear that she and other women partners tend to receive fewer points, sometimes like half as many points as their men colleagues, and that would translate to 2 or 3 times less pay. And then it kind of turned into a discussion about just how women lawyers tend to get paid less across the board and across the United States. So I just thought that was like an interesting comparison with Hopkins, especially since there's a 30-year gap between them, because this case is from like 2016, so it's 34 years or whatever, and how women in especially like professional fields in these two cases, and then kind of like the higher ranking areas of these professional fields are being like either excluded or like barred from leadership positions, or they're not being fairly compensated. And then when they bring this up, they're like terminated or have to go to court. But I just thought that was kind of an interesting comparison between the two.
And I saw you put in your notes that they had told Campbell, or she recounted her male colleague telling her she needed to learn how to behave.
Yeah.
So.
Yeah. So that also kind of goes into what Hopkins was talking about with sex stereotyping and the like stray remarks that her colleagues and other partners made about her and like her appearance and like attitude.
Absolutely. Thank you very much. So, Lucas, can you share your article?
Yeah. Okay, so my article was titled Oregon Transgender Woman Sues Miss USA Pageant. And so basically in this article, in December of 2019, Oregon's former Miss Oregon Elite sued the Miss USA pageant, which is based in Nevada, and claimed that their rule that limited competition to natural-born females was gender discrimination. Anita Green, the woman who was suing them, she's a transgender woman who was denied entry because she was born male, and the Miss USA is, to their one of their officials said it was, quote, a natural pageant. And she's participated in a bunch of pageants before across the world, Miss Universe, Miss Montana, and stuff like that. And she asked if they would change the rule so that she could participate in it, and they declined her. So she decided to sue them, and in her suit, she's claiming that the policy is discriminatory because it denied her full and equal advantages of their services, which violates an Oregon public accommodations law. So it's a little complicated because she's suing a Nevada-based business over a law that they violated in Oregon. But her lawyers are claiming that because of the way the pageant operates, because it operates on such a national basis, that it can be accused and held liable of violating an Oregon law. So it asks just for the change in the discriminatory policy, and she's claimed that she's trying to use the pageants as a stage to highlight all the difficulties of being a transgender person in America. So I just related this mostly to the videos and the readings, based in the fact that it implies a definition and a clear definition of like a natural gender or sex. And like the film calls into question that clear definition, talking about a lot of different cases with intersexuality and where sex is not a clear binary. And it's obviously a little different because it's transgenderism instead of intersex, but it's still kind of just a question of a black and white distinction between gender, male and female. And just because she was born biologically male, but she identifies as female, doesn't mean necessarily that she shouldn't be able to participate in a pageant, because there's not, especially the one that like claims that it only allows natural women, when that's not really a clear concept. So that was mostly how I related it to the readings.
Okay, great. This will be interesting. So they're using public accommodations law, right? And so we think about, you know, a company like Walmart or something, right? They have to follow the law in the different jurisdictions that they operate. But Miss USA is interesting in that it's a pageant and they draw from all over, but they're still based. I mean, I'm guessing they host the pageant at different states, but yeah, so this is going to be definitely something to watch with the new line of legal reasoning that they're looking at. So this is great. Thank you, Lucas. let's see, is Parker on? I know there are a few people who said they would have a hard time. So I don't think Parker's here. So a number of people were having some problems with connection. Andrea, do you have one?
Hi, yeah, I do. Can you hear me?
Okay, yes.
Okay, sorry, I don't think it ended up posting, but I do have one.
Okay, okay. Yeah, I don't see it. Okay.
Yeah, but it's called Supreme Court Clashes Over the Meaning of Sex in LGBTQ Discrimination Cases. This one's actually from, I think, October of last year, where they were deciding on the 3 LGBTQ cases, involving 2 gay men and a transgender woman who were filing suits under Title VII. And basically, this article kind of goes through the discussions of the justices of the actual word of the word sex in Title VII, whether it can be seen to include gender identity or sexual orientation or both. So in the beginning, talked about some arguments from Neil Gorsuch and Brett Kavanaugh that said it wouldn't fall. Well, first of all, they thought that they didn't have a right to discuss the cases. They thought that because they were extending Title VII to include workers who identify as LGBTQ, it was something that was needed to be taken into account by Congress, and that this wasn't their decision. They shouldn't be talking about it. One of the Republican appointees, one of the justices, actually talked about how in the past Congress had the opportunity to add and open up Title VII regarding LGBTQ workers, but it hadn't been done. And so it was a discussion of why should we do it now if Congress decided not to do it before. But then in that same conversation, RBG stated that there, in the past, have been interpretations that have been added to Title VII, so it's not something that's crazy or that hasn't been done in the past.
Right.
It was just an interesting interaction between all the justices regarding the word sex, what it means, and how it could change all these cases. And I related that back to the Price v. Waterhouse, because they were discussing heavily the difference between it was because of or for about or something.
And yeah, but for
yeah, and how they were discussing that and how that could change all the cases, and that's why they remanded it back, and how it would have been decided differently if the justices had decided on one word or one phrase, and how that would have gone. And that's how I was gonna bring it back together to that.
Oh, great, thank you. And one of the things is the EEOC and their administrative interpretations of because of sex actually had expanded the definition to include sexual orientation and gender identity in their guidance for employers. And in their interpretation, this was under the Obama administration. And it looked like, I'm not going to get too much into it now, but I see someone had talked about an equal rights amendment, one of the that keeps being proposed to add this to federal law, but essentially, yeah, it hasn't gone. And then so with the new administration, basically, they have pulled back on that. So, all right, thank you, Andrea. Is Lauren on the call?
Yeah, can you hear me?
Yes, we can.
Okay, so my article was about Mississippi appealing to federal court considering a ruling that said the state's ban on abortions at 15 weeks and beyond of pregnancy is unconstitutional. And it just talked about how, in a larger context of multiple states trying to enact laws like that, it's aimed at spurring court challenges that could eventually seek to overturn Roe v. Wade. And it was mostly about the viability of the fetus, whether or not it can survive outside of the womb past 15 weeks, and how that essentially takes away the autonomy of the person who is pregnant. And it also consistently uses, it didn't seem to consider transgender folks either. It was mostly all of the language didn't consider for people who might have a uterus without necessarily being women. And so I think I actually forgot to include this in my post, but it made me think of the part in Greenberg, I think it's chapter 2, about who has the right to choose my sex and genitalia, and how this baby essentially had a very invasive exploratory surgery and couldn't consent to something like that. And it just made me think of, healthcare ethics and who gets to have a say over what surgeries are performed or aren't performed on them. So, yeah.
Absolutely. Thank you. Yeah, this whole issue of consent and autonomy. Thank you. So, is Allie, Alyssa, you have an article?
Hi, yes, I do.
Hi.
Hi. So I found an article and it was called Elk Point School District Settles Sex Discrimination Lawsuit filed by a former student. In that case, it kind of reminded me of Price House versus Hopkins just because of judging her on the basis of sex. And so what happened was a girl in South Dakota in high school, she wrote in her yearbook Netflix and chill with her boyfriend is what she liked to do, and this was a term that she heard with like other males use at her high school, but her principal took her out of her honors club and they took her out of honors study hall and took away her senior privileges and made her write an apology. And so I think, and also I was wondering why they settled since it was so obvious that, she was discriminated against. But they ended up settling for $65,000. But it was just interesting to see how, in Price House versus Hopkins, how, they use language like she's abrasive and just the way he acts. And like we do see a lot of males who can act that same way in those types of positions. So I just, I found that interesting. And I also, like I said, it was interesting that they settled.
Yeah.
So.
Yeah. Yeah. It's hard to know, but it's, trial is a lot. Yeah. So, yeah. Let's see here. Well, thank you very much. So let's see, is Ezra on the call? I don't think. Okay. And she wasn't able to connect. Is Paxton on the call? No. Okay. Let's see here. Emily, can you share your?
Yeah.
Yeah. Thanks.
My article wasn't really revolved around like a specific case, but it was more revolved around just like the legislation and policymaking in Michigan specifically. So one of the cases that the Supreme Court is currently hearing, one of the 3 cases with the transgender woman, is actually a case stemming from Michigan. And in that particular case, a woman, she was working in a funeral home, and at the time she was presenting as a man, and she disclosed to her employer that she was going through transition and that she was going to be switching up her gender presentation to what she feels is right for herself. And after that, she was fired because of that. And Michigan is like kind of known for being a swing state, so the article kind of discusses how like this case going into the Supreme Court raised so much awareness for transgender rights and gender identity rights in Michigan, and how the state is now they're borrowing it on the ballot to have gender identity and sexual orientation explicitly stated in their version of their Title VII protective rights, because right now it's like more for interpretation, so it depends like case by case and like who's the judge at the time and things like that. And I said it was relative to what we were learning in class, because it kind of goes with that chart that you showed in the PowerPoint of how like every different state has their own or lack of protections. So it makes it very difficult for the LGBTQ community to like navigate their protections and their rights when they move across state borders. And how and the article kind of seemed like it was more like a motivating article, trying to get voters out there and spreading awareness that like even though the gay marriage rights and all these new progressive legislation federally has been enacted, states are still pretty far behind. So it just talked about that and how Michigan in itself is trying to get to the same standard that we want the Supreme Court to be at, and how even though like a lot of people and even corporations, businesses, they're on board with changing the laws to include gender identity and sexual orientation, it's still very difficult to do so.
Great article. Thank you, Emily. Is Grace on the call? No. Oh, you are. There you are. Hi.
So I did the same case in the same article as Hamza.
Okay.
You want me to talk about it still? Or?
Well, is there anything you'd like to add?
Nothing that hasn't already really been said. I do think it's really interesting to like, once again, and just in terms of like language and how a lot of it is just over the definition of sex, because that is all technically that is included in Title VII, but like it just says and sex. But now, as you know, history is progressing, we're realizing that there's like a lot of different terms that could involve or that could mean. And so the article, specifically the New York Times article, really touched on that, and how like, does it include sexual orientation? Does it include transgender people, etc.? So I just think that's a really interesting aspect in terms of looking at the law.
Okay, great. Thanks, Grace. Yeah, and one of the things, just as we go forward in the quarter with doing our articles, and I know it's harder because we're on Zoom, but if somebody brings up an article, so like when Hamza talked about that, and then I was asking if there were others who had the same article or a similar article on the same case, we'll jump to those people so that we can compare the coverage at the same time. Definitely. So it's hard. So if that happens, we only have a few people left, but you can even just put in the chat like, hey, I have a related article, and then I'll make a point to go to you next. Yeah, so that's for everybody. Thank you, Grace.
Yeah.
How about, let's see, is Matthew Amaya still on? I don't see them. So, and Mackenzie, is your, she's still there, but I don't know. Mackenzie, is your microphone possibly working now? We still can't hear you. I'll go ahead and read part of it. Sound good? So she had an article from the Seattle Times. And it was talking about also the Supreme Court case. It takes, so she's talking about the current case. And so one of the cases it discusses involves Amy Stevens. And this was the same one that Emily was talking about, the funeral home. So let's see, how did Mackenzie relate it? Okay, I'm just gonna read a couple of her paragraphs. The article explains how the lawyers for the employees argue that discrimination against someone for their sexual orientation or gender identity falls squarely within sex discrimination under Title VII. So when an employer discriminates against an employee because of their sexual orientation or gender identity, the underlying problem is the employer's assumption about what it means to be male-female, as well as how the individual should act. Let me see. The article mentions the Hopkins case by year, and the employees' lawyers argued, according to the article, that if the Hopkins versus Waterhouse case is precedent for sex stereotyping to be considered sex discrimination, then sexual orientation and gender identity discrimination must also be considered sex discrimination, since they're entirely based on sex stereotypes. So that's a great point to bring in. Though these cases will not be decided until June 2020, the article discusses how conservative justices are not as set against ruling for the employees as one might guess they would be. The gender pluralism article discusses the conservative agenda on this issue. In short, the conservatives focus on the immutability of the sex assigned at birth as the only legitimate gender of a person. However, according to the article, the conservative justices seem more concerned with the First Amendment rights of religious employers to make hiring decisions that do not conflict with their beliefs, and the fact that extending legislation is an act Congress should take, not the courts. In other words, the conservative justices, according to the article, do not seem as focused on the gender is immutable argument as Curraw's article claims they are. So great points. So yes, thank you. Wish we could hear your voice, but this will suffice. Is Leilani on? So no, let's see here. Natalie, did you share? You didn't share yours yet, did you? I know you talked earlier. Hi.
Hi. Yeah, so my article, it's kind of an old article. It's like 10 years, or yeah, 7 years old. But it's talking about how, like, since 2010, there's actually been discrimination against women who are asking for mortgage. Like, mortgage lenders have been discriminating against women who are pregnant or on maternity leave because they made assumptions about what that means. Whether, like, that means that they're not getting paid, that they don't have a job to return to after they have their child, or that they just won't even want to return to work. And so therefore that makes them like a financial risk in giving them a loan. But even though like the Department of Housing and Urban Development, they launched an investigation, and they did find that lenders examined the incomes of new parents a lot more closely than other borrowers. But by law, if borrowers have enough current income to qualify for a loan and demonstrate that they will be returning to work, then they can't be denied a loan. And I related this to the Price Waterhouse v. Hopkins case, because it kind of demonstrates how there could be kind of a blurry line between what is discrimination and what might be like a legitimate business concern. Because it's not uncommon for banks or anyone who loans you money, like they need to see that you are not a financial risk. That anytime you ask for a loan. But I think I don't know what the law says, but that should be more limited to like what you've demonstrated in the past. When they gave you a loan in the past, like how reliable were you to pay it back, or things like that. And in this case, they're making assumptions about how women will behave, based on sex stereotypes of women as belonging, or either belonging or wanting to belong to the domestic sphere, or making assumptions about what having a child means for a woman. And so that's why it's illegal, like when you're buying a house, like they can't ask you like, when are you going to have a baby? Or in any situation, they can't ask you when are you going to have a baby, because they make assumptions about that. So
yeah, and that's actually really interesting. When we talk about employment, we'll talk about too this whole concept of opening the door. So lending, like you're talking about, they're not supposed to ask you that. Employment, they're not supposed to, but if an individual brings it up themselves, then they've opened the door to that. Yet it's still an impermissible factor to consider in the decision making. but human nature is such that once you have that information, for some people, it's hard to differentiate. So I think that's a really great point in another arena in which this comes up. So thank you, Natalie. So is Hope available? Trying to see who's still. Hi, can you share your article?
Yes. So I had an article centered around sexual harassment, and it's about this woman, Alexis Marquez, who sued the New York State for ignoring her complaints of sexual harassment in the workplace. And she worked for a courthouse in Lower Manhattan. And so as their defense, the state claimed that she had not actually been an employee of the state, and that her boss, Justice Douglas Hoffman, could only actually face the consequences, and so the state wasn't liable for that. Yeah, and I kind of just talked about the relationship between employees and employers, kind of like in Hopkins, and they kind of use the Title VII to their advantage because it excludes the personal staff of elected officials. So they kind of use that as their defense. Yeah, and a ruling hasn't been issued yet, so.
That's really interesting. Yeah.
Yeah.
To make that exemption. Thank you. That's a great case. Joseph, are you on the call? No. Okay. So let's see. Tara?
Yeah, I'm here.
Yay.
So my article was from the WAPO, and it was kind of like an overview of all of the cases surrounding not only Mike Bloomberg, but Bloomberg LP, his company, regarding sexual harassment. And also there were a number of Title VII cases that came up from 2007, or I think it came up in 2007, but detailed issues that happened from 2002 to 2007 regarding women who were pregnant or had just returned from maternity leave. And I forgot to mention this in the actual, like on my blog post, but it was actually a Title VII case. And it would, like the women who came back from maternity leave or were pregnant, like face different, different sort of penalties for being pregnant, including reduced pay and having less responsibilities, demotions, like exclusions from different meetings, and also like this sort of like fitting into like what we're talking about with the stereotyping of women and like having them be their role as caregivers and mothers, and rather than like, and that role carrying into the workplace. But there are also different cases regarding allegations of just like lewd comments towards women, like borderline sexual harassment, just like really awful stuff to read about. And this reminded me of the Martin Marietta Phillips case, just when we're talking about like sex plus, like what like other things besides just gender can women and gender nonconforming and transgender people face in the workplace. And it's not just gender identity in that case, it's also like I guess like even like I guess motherhood's part of it, but also just like taking time off or like having certain biological needs not necessarily met in the workplace. And it also reminded me of the Price Waterhouse case when we were talking about stray remarks, especially when it came to the comments that Bloomberg and other executives made towards female coworkers in the office. In terms of also thinking about O'Connor's comment about stray remarks and whether if the statements were made in the context of, you know, an employment decision, would this be sufficient evidence to call for gender discrimination? And these cases, a lot of them I think were dismissed in 2011. So there's all the pregnancy bias claims were dismissed.
This is Yeah, this is a great example. Yeah, thank you very much, Tara. Is Maddie or Madeline on? No? It's all right. How about Ariel? Are you still on?
I am.
Hi.
So I brought an article about the U.S. women's soccer team's lawsuit that they're bringing against the U.S. Soccer Federation. And I thought it was interesting, basically, in terms of background, the U.S. women's soccer team is alleging that they are paid significantly less than the men's team. What makes it interesting and complex is that they are paid by different entities, like sub-entities of the U.S. Soccer Federation, and they are have different collective bargaining agreements. However, because they're within the same sport, same framework as the men, they would like to be compensated in the same way. And I thought it was interesting in regards to the test that was brought to that like a supposedly neutral test on its face that impacts a protected group unequally is not allowed under the Civil Rights Act. What the U.S. Soccer Federation is, their evidence is that the value that the women get paid is in fact more than the men's team. But like once it's broken down and the individual frameworks of the systems, the women are well underpaid. So I thought it was a really interesting, this like very complex and very public example.
Yeah, no, that's a great example. Yeah, what you're talking about with the facially neutral explanations, and so them going back and be able to look as to whether that's actually is neutral as they're saying, right? Which is what you're talking about. So excellent. Thank you, Ariel. So I have a few things for us to discuss before we break today. I have some hypothetical questions that I'm going to present to you and talk about how to go about answering these hypotheticals. And so we'll talk through the first one, and then the rest of them we'll go through a little bit now, the factual scenarios, but then we will discuss them at the beginning of class next week. And so you'll see that and also next week you'll start getting your short quiz on the week prior's work, and you might also get hypotheticals in the future and things. So this will be helpful in how to approach those. So let me go ahead and share the screen. Let's see here. Okay. So I am hoping that I'm going to make it full screen and swap displays. Hold on. Okay. Can you all see that hypothetical? I can't see anybody's face, so if you can't, unmute and tell me you can't. So
yes, I can see it.
Okay, awesome. So the first hypothetical, actually, would somebody mind reading it? I talk so much, so if somebody would read it for us all, and then I'll talk about how to approach answering this type of question.
I will.
Thank you.
Patricia, a recent business school graduate, was interviewed for a position as a marketing assistant for a public relations firm. At the interview, Bob, the manager of the department with a vacancy being filled, noticed Patricia's wedding ring and asked, "How many kids do you have?" Patricia told Bob that she had no children yet, but planned to once she and her husband had gotten their careers underway. Bob explained that the duties of marketing assistant are very demanding, and rather than discuss Patricia's qualifications, he asked how she would balance work and childcare responsibilities when the need arose. Patricia explained that she would share childcare responsibilities with her husband, but Bob responded that men are not reliable caregivers. Bob later told his secretary that he was concerned about hiring a young married woman. He thought she might have kids. He didn't believe that being a mother was compatible with a fast-paced business environment. A week after the interview, Patricia was notified that she was not hired. Believing that she was well qualified and that the interviewer's questions reflected gender bias, Patricia filed a sex discrimination charge with the EEOC. The investigator discovered that the employer reposted the position after rejecting Patricia. The employer said that they reposted the position because they were not satisfied with the experience level of the applicants in the first round. However, the investigation showed that Patricia easily met the requirements for the position and had as much experience as some other individuals recently hired as marketing assistants.
Okay, thank you, Ariel. So in approaching a question like this, we would use that same IRAC format that we talked about for the case brief. So what is the issue that you're trying to decide? What is the rule for the hypothetical, or what's the rule for this legal issue? And then how would you apply the facts from this to the rule, or any precedent, so Title VII or any case precedent, and that would be the analysis, right, in the conclusion. So, right, what's the issue in this hypothetical? Right, so what's Patricia's issue, legal issue?
It was possibly like, was Patricia, sorry, someone.
That's okay.
Was Patricia, was the decision of not employing her made on the basis of her, I guess, like, that she disclosed that she has plans to have children?
Yeah. Yeah, so it would be this whole issue, essentially, was she discriminated against on the basis of her sex, because part of the hypothetical talks about how Bob, the interviewee, said men are not reliable caregivers, right? So there's this clear piece. So, so was this is this because of sex, is essentially under Title VII. And so the rule would be Title VII. And I'm wondering if anybody would like to tell us what they think based on what we've covered today. Would this be impermissible sex discrimination, and why?
Am I able to speak?
Sure.
Okay. I'm wondering if it would be because of how, like, it says that he wasn't asking her, like, discussing her qualifications. He was asking about work and childcare responsibilities, which, like, he probably wouldn't be asking like a man, or like he wouldn't be asking someone who wasn't going to be bearing children, or someone who, like, was talking about children at all. Like, and that, because of him focusing on that instead of qualifications, it becomes, like, I guess, possible that he was, how you call it, like, that was the deciding factor. Yeah.
So great. So we're going to hop back to a slide. So we have disparate treatment, right, is what she's saying, that she was treated differently. And so then the first question is there a prima facie case? So let's just jump to that slide. So she a member of protected class? Yes. Did she suffer an adverse employment action? You could say yes. And then were non-members, so in this case were men treated more favorably in the same situation? And we say yes. So it looks like she has a prima facie case, right? So she could get past that. So then the next question, is there a legitimate and non-discriminatory reason that the employer gives? So let's go back to this hypothetical. What's the reason that the employer gave, right? So they said that they didn't have, wasn't satisfied with the experience level of the applicants in the first round. So right, so that's the reason they gave, and then she can come back and show pretext. So show that that's factually correct or incorrect, or that they're lying. And so she comes back and shows, right, that she had as much experience or more as other people who'd already been hired, right, as marketing assistants. So based upon that, right, the shifting test that we're talking about for disparate treatment, so she has a prima facie case, we know what the business reason is, and then they come back with pretext. I'm going to ask Sophia Annis, since you're on there, what do you think? Do you think that she could succeed on this disparate treatment case?
Yeah, I think she could succeed because if I'm remembering correctly, he asked how many kids she had first, which prompted her to then say that she was planning to have kids. She didn't just like give that information away without being asked the question. So yeah,
that's a good point. However, I'm going to push you a little bit farther.
Okay.
Because she did he opened the door. He asked, which he shouldn't have. So that's against the law. But even so, with that information, he is not supposed to make that decision based on that information, right? So even though he asked impermissibly, so that's a violation in of itself, even though she then volunteered the information, but that decision is it the decision because of sex? So was she not hired because of sex?
I still think yes, because he didn't ask about qualifications in the interview didn't talk about that, and I don't know how you prove the other interviews didn't ask those questions, but that would be the only way to prove that. I don't know.
No, these are tough. So good answer. Anybody else have any thoughts? What would you conclude? Would you argue?
I think that his quote when he was talking to like his secretary about how being a mother was not compatible with a fast-paced business environment is really telling, because saying that because she's like a person who's biologically capable to have children means that and like that she wants to have children as well, like means that she wouldn't be able to like be as productive or like whatever for this marketing assistant position, is like pretty telling that he was basing it off of her gender. And then like that was the reason that he made the decision not to hire her, because she already had the qualifications that other marketing assistants had when they received the position.
Right. So, she's saying this is pretext, is what I'm hearing you say, because they're coming back saying, well, there wasn't enough experience, but they'd already hired people she actually exceeded the experience of some of the people already hired. And so this was a way to basically not hire her. So, great. Thank you, Emma. So that is how you go through the analysis. And then if it in some way was similar to one of the cases in the analysis, when you did your IRAC for the answer, you would talk about the related case. I think here, you want to go through each of the steps of the legal test. And I've talked about this before, but it's like long division, right? Don't just tell me the answer, show me how you got there. And as we're going to see as we go throughout the quarter, that the rationale, right, the legal basis on which the decision made is very, very important. And so, I'm going to be grading you not necessarily on if I think you got the right conclusion or not, or if I agree with it, but whether or not you supported it. okay? Because in legal arguments, people are always going to argue at least two positions, right? And so again, you know, now I would say that definitely this one, there's some red herrings thrown in here, right? But if we're just doing that disparate impact, burden shifting, I thought Emma did a good job, and Sophia, you did too, in noting just the because of sex piece. But I think it's the red herring. It's easy to get caught up the whole who opened the door, and because the problem is even if she did, it's still impermissible to make the decision on that basis. Okay, so let's see here. So a couple other hypotheticals I'm just going to introduce to you, and then we'll talk about next class. And then I have a couple things to say just to get ready for next week. So the next one is the same facts as above, except the employer did not repost the position, but instead hired a man, Tom, for the same round of candidates. And Tom, and the records show that other than Tom's greater experience, Tom and Patricia had similar qualifications, but the employer consistently used relevant experience as a tie-breaking factor in filling marketing positions. So then, is this because of sex? Okay, so that'll be something we'll talk about. And then the last one that I have, actually, I'm sorry, there's 4 hypos. So this next one is Carla, who's an associate in a law firm. She returned from maternity leave, so we have a lot regarding reproduction. And she began missing work frequently because of her difficulty in obtaining childcare and was unable to meet several important deadlines. So as a result, the firm lost a big client and Carla was given a written warning about her performance. So Carla's continued childcare difficulties resulted in her missing further deadlines for several important projects. 2 months after Carla was given the written warning, the firm transferred her to another department where she would be excluded from most high-profile cases, but would perform her work, that had fewer time constraints. So Carla filed a charge alleging sex discrimination, and the investigation revealed that Carla was treated comparably to other employees, both male and female, who had missed deadlines on high-profile projects or otherwise performed unsatisfactorily and failed to improve within a reasonable period of time. So I want you to go through that same disparate treatment test that we just talked about. And then the last hypothetical is Simone, the mother of 2 elementary school age children, files an EEOC charge alleging sex discrimination after she's terminated from her position as a reporter with a medium-sized newspaper. The employer asserts that it laid Simone off as part of a reduction in force in response to decreased revenue. The employer states that Simone's supervisor, Alex, compared Simone with 2 other reporters in the same department to determine whom to lay off. According to Alex, he considered Jocelyn, an older woman with 2 grown children, to be a superior worker to Simone because Jocelyn's work needed less editing and supervision, and she had the most experience of anyone in the department. Alex said he also favored Louise, a young male worker with no children, over Simone because Louis had shown exceptional initiative and creativity by writing several stories that had received national publicity and by creating a new feature to increase youth readership and advertising revenue. Alex said he considered Simone's work satisfactory, but that she lacked the unique talents that Jocelyn and Louis brought to the department. So these are some hypotheticals I'd like you to consider. And then next week, we're going to get into intersectionality. So we're going to further complicate everything and talk about this, but this is real life, right? So I'll be posting by the end of the day Friday. So by 5 p.m. Friday, everything for next week will be posted. Most of it's posted now, but actually Dr. Ernst and I, with a former SU student who is about to become a professor, wrote an article that was published at the end of last year for the annual review of law and social science on the current state of intersectionality research. So I'm going to post that article for you to read because it's probably one of the most up-to-date pieces, and we'll talk about that. We'll get into the hypotheticals, and then I'm going to start adding some additional hypotheticals. So also look, next week you'll have a quiz, a short quiz on Monday over this material too. So before we go, any questions about anything? We're a couple minutes over actually. And I wanted to just compliment everybody. Your analysis was really fantastic with the articles. And so I'm really excited for the level of discussion and how deep we're going to be able to get into these issues in the class. So thanks again. Have a good evening. Stay warm and safe. And I'll see you next week. So bye.